Great. Good morning, everyone. Welcome to Friday the 13th, our introduction to the foreclosure prevention legal services practice training. This is a full day training, as everybody is aware. My name is Kirsten Keefe. I'm a senior attorney with the Empire Justice Center. And we are doing this training as part of the Homeowner Protection Program, HOP. So this training and all the trainings we do are funded through the New York State Office of the Attorney General's Homeowner Protection Program. This first session I will be doing with Jacob Inwald, and he can give a brief introduction of himself when he starts talking if he wants. But just to let you know, Empire Justice Center is the anchor partner for all the grantees outside of New York City. And then the Center for New York City Neighborhoods is the anchor partner for grantees within New York City. And they contract with Jacob Inwald to provide technical assistance and training for the legal service providers in New York City. So we are really excited to be doing this training in conjunction with Jay and Legal Services NYC for our HOP grantees. This training is designed as a one-day sort of boot camp, so to speak, introduction to representing homeowners in the foreclosure process in New York State. So there are a lot of things we will not be able to get into. It really is intended to provide you an overview. For each session, you will receive a CLE credit, and because people might be coming in and out of sessions, and we don't know that, for each session, you should have a certification sent to you by Michelle Peterson in our office, who handles all of our CLEs. Each certification for each session needs to be signed, and we will give you a code at some point during each session that you will have to put into the certification to return to Michelle. So please make sure you do that and send them to her timely so she can get the CLEs out. It's a huge job for her. I also do want to just take a note to thank Michelle so much. She has been managing our trainings for years at Empire Justice Center, and there is so much background work that goes on to putting these on. And I also just want to give a nod to Lisa Milas, who really organized this training in conjunction with Jay Inwald from Legal Services NYC. And I want to thank them both for really putting this training together and for all of the presenters that you will be seeing today. We are really trying to have a mix of different trainers through the day, so you're hearing from a lot of different people. And we hope you enjoy it. There are some breaks. Let me just get into the next slide. Do you see the next slide with the timed agenda? Jay, is that coming up?
Not yet.
There.
No,
is it up there?
No.
Okay.
Now you got it.
Okay. So the first hour will just be a real overview of who the players are in foreclosure cases and mortgage cases in New York State. And an overview of the foreclosure process. We'll have a quick break then, and then we will have two folks from New York City presenting on an overview of claims and defenses, as well as counterclaims, and really talking about answering foreclosure complaints. Then we will break for lunch, and then there'll be an hour session, an overview on the settlement conference process, which is so integral to New York State's foreclosure process and loss mitigation programs that are available. Another break. Then we'll have somebody talking about reverse mortgage basics in New York State, because there are a lot of reverse mortgages, and now New York State is going to start making reverse loans on co-ops. So somebody will be presenting on that. And then we will, later in the day, we'll have two breakout sessions, one for attorneys. And we know that there are a lot of paralegals and legal assistants attending this training today, which is great. So we are going to have two different breakout sessions. Jay will be doing one on motion practice, and then Kate Lockhart will be doing one on specifically for folks who are not lawyers, working with clients in a legal services office. And then at the end, we'll have a final session on sort of an overview of the end stages of foreclosure and talking about bankruptcy a little bit. I do want to note that one huge area that you will be seeing, if you haven't already in your practices, are tax foreclosures. They are sort of an animal in and of themselves, and we will not be talking about tax foreclosure defense in this session. And then also utilities can have liens on real property, and we will not be going into utility liens as well. And again, on all of these, we could spend a whole day training. But today is really, again, intended for an overview to really help you sort of issue spot in your cases, what might be going on, and then you can search for more information if you need it. I do want to let you know that there are a lot of resources out there in the foreclosure defense world. It is a very congenial group of folks. If you are new to this, we are very friendly with each other in New York State. We have a couple different listservs to which you can pose questions. You can always reach out to the organizations providing technical assistance under HOP, so that's Empire Justice Center, as well as Jay Inwald at Legal Services NYC. There are a lot of national resources. I would be remiss if I did any training and didn't mention the National Consumer Law Center. First of all, they have two very good trainings throughout the year. They have one mortgage-focused training that is usually in a different city, and a multi-day training that usually happens in June. So I would look out for that. And then they do a bigger conference in the fall that includes a lot of mortgage defense sessions, but it also includes a lot of other consumer law issues. So I really encourage folks, if you're able to get the funding from your program, to go to one of those trainings to do so. They are really excellent. They also have a set of manuals that are really excellent, and they have a whole manual specifically on foreclosure defense. They have a whole manual specifically on the Truth in Lending Act, and includes RESPA, one of the main statutes overseeing mortgage servicers. So there are a lot of resources in the materials that you received. Lisa and Jay prepared a great list of resources, including organizations and our state-based listservs that you can access for more information. So I really encourage you. No one should be doing this alone in their offices. You should always be relying on others for information and assistance. New York State really does have, I say, somewhat humbly say, among the best protections for homeowners in the country. I actually think that we do have the strongest protections for homeowners in the country. And New York State also has probably the best network of folks providing direct services to homeowners, between our network of housing counseling agencies and legal services, and also including the relationship that the legal services offices have with the housing counseling agencies throughout the state, and the relationships that we have with the courts. We really, I think, provide the highest level of services to homeowners in New York State. We are the only state in the country that has mandatory settlement conferences in residential foreclosures on somebody's primary residence. Some other states have an election for homeowners to choose it. But as far as I know, New York State continues to be the only state with mandatory settlement conferences, which really have been a game changer since they came into play. The final thing that I just want to say is, to quote Katie Porter, Congresswoman Katie Porter, banking issues are civil rights issues. I heard her say that once at a conference, and it has always stuck with me. And I will say that in New York State, foreclosure is definitely a racial justice issue. The last time I looked at data under the US Census tract, almost 16% of homeowners, 17% actually, of homeowners of color in New York State report that they are behind on their mortgages following COVID, as compared to 6%, almost 6% of white homeowners who report delinquency. So I think we can all appreciate how important it is to preserve homeownership for everyone. But specifically, when you look at the how behind individuals of color are in terms of attaining homeownership to begin with, we've had great losses of homeownership in communities of color over the years through the subprime mortgage lending crisis. And now foreclosures are sort of another threat to that. And so I think our services are vitally important to try to maintain the highest level, if not grow, home ownership among minority populations. So with that, and I should also note, so if you have questions, please drop them into the chat. Hopefully we will leave enough time at the end of this session to answer questions. Lisa Milas will be monitoring the chat for questions throughout the day. And so please drop any questions. And Lisa, if it's pertinent, like I didn't understand what Kirsten said, she was mumbling, please chime in and break in, but otherwise we can hold questions until the end. Okay, so with that, are there any questions so far, Lisa? Okay, great. Okay, so we can move on to the training. So again, this first part is just sort of to give you a sense of the documents and the players in the mortgage world. So first of all loans are made by an originating lender. The originating lender usually is not the party that you will ultimately be dealing with, but the original lender will always be listed in the mortgage documents, and you can find who originated the loan in the mortgage and note. Mortgage loans are originated by depository institutions. So your Chase, Citi, your local credit unions, the storefronts that you see on the streets certainly make mortgages. Then there's I think, sort of growing body of non-bank lenders. Folks are probably familiar with Quicken Loans, PennyMac, Loan Depot. These are often, folks access them online, and all they do is originate mortgages. They're not a bank otherwise. And then you have non-traditional hard money lenders, which are not very common, but there are other lending schemes of folks who might make mortgages. One other category that I would just mention in here are private lenders. We do see loans made to homeowners periodically by, for example, the seller of the house. And so a seller of a house might sell the house to a buyer and hold the mortgage themselves. So a private lender like that may not, you'd have to really look at the rules. They may not be subjected to the consumer protections that cover all the other entities. I do want to just note here too, there is a category of folks who don't get mortgages, but buy homes through sort of lease sale agreements. Land contracts is what they are typically called. Instead of selling my home to somebody and holding a mortgage, I might say, I will sell my home to you. You live in the home. You are responsible for taking care of the home, for paying the taxes, and then you make an additional payment to me, essentially as rent. But it is intended that at the end of some term of you paying me rent, you will own the home. So that is a separate category. I'd say in New York State, we hear about those most often in the Southern Tier section of New York State, but they could happen elsewhere. And then the final category that I will just mention are folks in manufactured housing units. We will not talk about these as well during the training, but I do just want to note those. They are very different. These are individuals who own the home, but the home is located on property that they do not own, real property that they do not own, and they lease that property. Manufactured homes are treated as chattel. They are treated much more like buying a car than buying a house, and there are different levels of protections. So I just wanted to flag those for folks. Moving on, so the note and the mortgage are the two main contracts, of course, that you will be dealing with. And I do want to note that they are two separate contracts. The note is the contract to lend money to somebody to purchase a house. And it is in the note that you'll read all the terms of the mortgage. So the amount of the mortgage, the interest rate, the term, meaning the number of months they will pay. If it is an adjustable rate mortgage, the terms of the adjustable rate will be set forth in the note. The note will also include provisions like what happens if somebody doesn't maintain their property taxes, if their property taxes are not otherwise escrowed in their mortgage note, or what happens if they fail to maintain the property at all. What happens if they fall behind on their note, what steps the lender can take in terms of bringing a foreclosure action, as well as what the lender might be entitled to collect in fees and costs if they do have to bring a mortgage. So you should definitely read the note. Fannie Mae and Freddie Mac have sort of standard security instruments, which I think are widely used, even if a loan is not connected with Fannie Mae or Freddie Mac. But you do always have to read the contract and become familiar with those. And that's always the first place to go if something happens. The mortgage is just the security interest in the property. The mortgage says, I'm borrowing this money under the note, and if I do not make my payments under the note, I am giving you a security interest in my property, so you can then bring a foreclosure case to collect off of my property for the value of the note. A lender could bring an action if somebody defaults on the note. They could bring an action under the note, which would not be a foreclosure, or what happens in the vast majority of cases, they opt to bring a foreclosure action to actually foreclose on the house and then be able to sell the house and use the proceeds of the sale to pay themselves back for the amount of the note. A note on the secondary mortgage market. So mortgages and notes, I should say, because they do have to follow each other, are bought and sold and often on the secondary market. And the secondary market was really created as a way to pool mortgages together, sell them into the secondary market, and generate more capital for more mortgages to be made. And it really did do that at the very beginning, and it continues to do it. It's a way to generate more capital into the mortgage lending world in the United States. Folks may recall back in the 10 years ago, 15 years ago now almost, there was a lot of pooling of mortgages and selling them onto to Wall Street. A lot of the mortgages that were going into those pools were destined to fail, and in fact did fail. And it is then those investments that ended up failing on Wall Street. And, you know, that is a very one sentence explanation, simplified explanation of then, you know, what caused the financial crash. It was the securitization of mortgage was part of that, but they were just selling, you know, pools of very, very bad mortgages, again, that were destined to did default in fact, and that is what really caused the crash 15 years ago. Fannie and Freddie Mac securitized loans, for the most part in the United States today. You might have some private investors that are still pooling mortgages together. The one thing you might have to go to, if a mortgage is ultimately sold into an investment vehicle to Wall Street, you might end up having to go to an agreement. It's called a pooling and servicing agreement to see additional terms, especially whether or not there are specific terms around loan modifications or the other loss mitigation options. We will not get into that today. That's a very complicated area, but just to let you know that there might be another set of like contracts that you have to refer to understand what your servicer can do in terms of working with a homeowner who is behind. Oh, I'm sorry. I'm sorry. I have two sets of slides and I'm not looking at the right set of slides and moving them forward. So I will just pause for a second so folks can read through what is on this regarding secondary mortgage market. And then securitization, I talked about as well already. I will note that if a loan is sold on the secondary market, whoever, whether it's a trust or whoever owns that mortgage, will hire a separate servicer. You will not be dealing with the trust. You will be dealing with an independent servicer. But just keep in mind, typically the servicer is not the true owner and holder of the mortgage and note. It would be in a trust or some other vehicle. Okay. So mortgage servicers, is that the slide that you see on my screen? Okay, thank you, Lisa. So mortgage servicers are the ones who handle the day-to-day tasks of managing a loan. Mortgage servicers, their behavior is mostly regulated through the Real Estate Settlement Procedures Act. And then this Consumer Financial Protection Bureau has a set of regulations that oversee servicer activity. And New York State, we have our own set of mortgage servicing regulations that have been promulgated by the Department of Financial Services. They are referred to as Part 419, business conduct rules for mortgage servicers in New York State. But generally, the mortgage servicer is the entity that will be collecting payments, and there are rules about how they have to properly apply payments. They are the ones who will respond to any inquiries from borrowers. They have to manage the escrow account, and there are specific rules under RESPA for how escrow accounts are managed. Just to note, and so we're all on the same page, this is a basic training. Escrow is an amount above and beyond a principal and interest payment that a homeowner has to pay each month that goes into essentially a savings account to be used then by the mortgage servicer to pay taxes, property taxes, as well as insurance on the property. So you will often see in the note the straight monthly payment that consists of a principal and interest that goes to pay back the money that was borrowed. But then the majority of lenders require homeowners to simultaneously escrow each month, again, make an additional payment that they will ultimately use to pay the property taxes on an annual basis and the insurance. They do that because it is in their best interest to make sure certainly that the insurance is being kept up on the home, because if there's a fire, they want to make sure that their collateral is protected. And the property taxes, they want to make sure are paid on a monthly or on an annual basis, because if a homeowner falls behind on their property taxes and a taxing locality brings a foreclosure action against them, the taxing authority essentially will supersede the position of the mortgage company and could get paid first, and then the mortgage company might not fully get paid what they're owed out of the foreclosure. So they have a very vested interest to make sure those two things are paid on an annual basis. But it is the escrow account that might increase from year to year and will likely increase certainly over the course of 5 or 10 years on a mortgage, because property taxes continue to go up. And that is why somebody might have a fixed interest rate on a mortgage, but their monthly payment might change from month to month or from year to year. The mortgage servicer also has to send mortgage statements. And it is most importantly, I think, for our purposes, it's the mortgage servicer who you will be dealing with who negotiates the any kind of loss mitigation options or repayment options once a homeowner falls behind. Sorry. Okay. So government insured and guaranteed mortgages. There are different mortgages that are made, and they were really designed to promote home buying in lower income sectors. And these loans are insured or backed by different entities of the federal government. So the most common, I think, that folks hear about are FHA loans. So FHA loans, these loans would be, the money would come from the lender who is making the loan, but the loan itself is insured by the federal government. So M&T Bank may make an FHA loan, and there are requirements that they have to adhere to in the origination of the loan and making sure the property, they might have to do more inspections, et cetera, to qualify for an FHA loan. And then there is qualification for the borrower eligibility for FHA loans as well. M&T might make that loan, but ultimately, if that loan defaults, M&T, presuming they retain the loan, would continue to work with the borrower. But at the end of the day, if the loan went into foreclosure and if M&T lost any money on the loan, the federal government would come in and indemnify, reimburse M&T for that loss. So FHA loans are probably the biggest category. There are USDA loans. These are loans that are typically made in more rural areas. I will say that they are not very common, but there are loans made through the United States Department of Agriculture. The Department of Veterans Affairs, VA loans are more popular or more common than USDA loans. They are less common than FHA. They are more common than USDA loans. And then you have different guarantees from Ginnie Mae on other mortgages out there. The reason why it's important to know what kind of loan it is that these are all insured by different federal agencies, and they may have they probably have different loss mitigation protocol and options available to the homeowner. So it is very important to know whether or not you are dealing with an FHA, VA, USDA, or other mortgage out there. I will note it's not on this slide, but in New York State, we also have Sunny Mae loans, the State of New York Mortgage Assistance. State of New York Mortgage Association, I believe is the name. And those are loans, again, they are intended to promote homeownership among lower income buyers. And those are loans that are, again, made by lenders, but they are insured essentially or backed by the state of New York. And they have different servicing criteria when somebody falls into loss mitigation. Whoops. So there are three main classifications of loans. Non-conventional loans are the category of loans that are typically backed by federal agencies, FHA, VA, USDA. Conventional loans refer to all private sector loans, loans made by your local credit unions, depository banks, etc. Conventional loans get into two different categories, conforming and non-conforming, which really just looks to the loan size. Jumbo loans are in a classification of non-conforming loans. I would say for the most part, folks will just be dealing with conforming loans. And then portfolio loans that term refers to loans that are held by a bank. So if M&T makes a mortgage, and they do not securitize that mortgage and sell it into the secondary market, but they retain that mortgage and service it themselves, it's considered a portfolio loan. Whoops. Okay. And then one final slide before I hand it over to Jay to talk about the foreclosure process in New York State, which is more interesting than the background. I just want to note that there are a lot of scams. We do not go into this in this training other than this slide, I think, today. But just to, again, red flag it for you, that there are a lot of scams that happen to homeowners. There has been a whole classification of home equity theft. And these come in many different ways, but it's essentially, preying on folks who are behind on their mortgages, and someone comes and offers to help them out. And, we can transfer the property into our name. You can cure your credit, we'll lease the property back to you. And then at the end of the year, you can get your own mortgage and buy the property back, etc. There are many, many different variations. That's sort of an older variation, but there are many variations of it to keep an eye out for. There are a lot of what New York State calls distressed property consultants who offer to essentially do what you are doing for a lot of money, and they don't do what they offer to do or what you do to anywhere near the extent. These folks usually reach in from outside of New York State, although there certainly have been some players that have been located within the state, but they really prey upon folks. We've done a lot in New York State to try to prevent scams from happening to homeowners. Our primary defense has always been the HOP network and making sure that we have services available in every county of the state, both housing counseling and legal services, which we have been successful at doing for over 10 years, I'm happy to say. We have we have notices that are sent to homeowners who are in distress saying, beware of scams, definitely contact a HUD approved housing counseling agency or another agency within the HOP network. I note the Home Equity Theft Prevention Act here, which is a law that specifically targets some versions of home equity theft. But again, the main purpose of this slide is to, question what you see and be aware that there are a lot of scams that still come into our homeowners, but we do have tools to combat them. And if you ever see it, reach out. So with that, I'll just pause quickly and see, Lisa, if there are any specific questions on the portion that I did. Okay, I will hand it over to Jay Inwald.
Good morning, everyone. Hi, I'm Jay Inwald from Legal Services NYC. Looking at the screen so far this morning when Kirsten was talking, I realized that I'm providing the portion of this day that's the equivalent of the two old guys up in the balcony on the Muppet Show, the cranky old men who sort of comment on everything that's going on. So I'm going to be playing that role at various points today. But seriously, I'm really thrilled to see how many people we have on this training for new advocates, which is kind of a testament to the success that we had last year, really getting adequate and substantially increased funding for the HOP network. Although I will say we have a lot of experienced people who are sitting in today as well. Not all 128 of you are brand new to the practice, but it's still nonetheless really encouraging that we have so much new blood really amplifying our work. So thank you all for being here.
Jay, can I just jump in? I'm so sorry, and give the code. I'm sorry, I wanted to jump in after mine. Sorry, everyone. So this is the code that you will need to write down on your certification. It is SNOW 13, SNOW 13. And we will put that in the chat as well.
Thanks, Kirsten. So, and then the other thing I'll say, which, Kirsten did a great job sort of laying out the cast of characters that we deal with. But leading into what I'm going to talk about is there's other cast of characters that we as attorneys or advocates at legal services organizations have to deal with, who are our opposing counsel, the lawyers who are actually prosecuting the foreclosures in court, because a big chunk of what we're talking about today is the cases that we're seeing in court. So there are law firms in New York who specialize in prosecuting foreclosures largely on a high volume basis. Most of you have already encountered them already. We sometimes not so nicely refer to them as foreclosure mills because they do prosecute, with large numbers of cases, and also largely thanks to our being on the ground and sort of changing the landscape a little bit, we often see in contested cases large Wall Street law firms who are representing the banks, who they bring them in when there's more of a litigation posture in the case. So, and then one thing I'll just mention also in terms of the cast of characters, because many of the law firms that prosecute high volume numbers of foreclosure cases in New York, among the cast of characters that some of us may be encountering in our daily lives are what we refer to as per diem lawyers. So some of the foreclosure firms don't have huge numbers of on-staff attorneys, and they actually employ lawyers who are retained for purposes of handling court appearances. So in many counties, you'll see what we refer to as per diem lawyers who are actually picking up the files and covering the conference for that particular day, who may not have any ongoing relationship with the file or any relationship with the client. So that can sometimes be part of the challenge of doing this work. And that may come up a little bit more in the session later on in the day when we're talking about settlement conferences. But all of this goes to the fact that New York is a judicial foreclosure state, and foreclosure is a litigation process. So it's really, important that we keep that in mind. For the most part, most of the clients that you are seeing are defendants in a lawsuit which is seeking to foreclose on their home, and they're consulting us as lawyers, and everything that entails is implicated because their home and substantial investment, probably the largest investment they've ever had, is at stake as a result of this litigation. So that's just always important to keep in mind. The other thought that I just wanted to mention is because I came to this as a second career, and I actually thought the subject of foreclosure was going to be completely deadly and mind-numbing. And in fact, it's really interesting, and it takes in such an amazing variety of subjects. I wanted to sort of step back and make sure people are aware of how much in their ordinary work they're actually touching upon or gaining expertise in all kinds of other areas, or just all kinds of areas that are really essential to this work. So just indulge me and let me sort of, talk a little bit about this. Like, obviously, because this is a lawsuit, front and center is civil procedure and evidence law. And you're going to be hearing more about this later on when we talk about the defenses and we talk about motion practice. This is a lawsuit, and we win our cases when we master the laws of civil procedure and when we master the laws of evidence, in particular in this practice area, because even after all these years, lenders often lose their cases just for failure to muster admissible evidence to establish such basic things as whether the homeowner was even in default or whether they owned the loan, and other issues, whether they complied with predicate notice requirements that you'll be hearing about later. Most of you have been here probably long enough to be receiving from me almost daily, or at least, a couple of times a week, an update that's, flags recent case law. And if you review that case law that comes around every week, there's usually more than one or two cases where the plaintiff lost the case because they just did not come up with admissible evidence to establish something basic that they require to win their case. So that's just really important. Real estate law obviously is part and parcel of what we do, and we need to sort of deal with these issues without even thinking about them. We're always dealing with them, whether it's lien priority, issues around how property is held and owned, whether there are tenants with joint tenants with rights of survivorship and things like that. We confront partition actions, in particular in New York City lately. There have been a lot of partition scammers who were buying fractional interests in properties, and then trying to force out long-time, other family members. So that requires a mastery of a lot of real estate subjects. So that's really front and center in our work. Corporate law, Kirsten touched on this, really alluded to it. So crucial to so much of the work that we do is understanding the process of securitization that took place, whereby the party who is now foreclosing on the loan got their interest in the loan. And that can have a lot to do with whether they actually have standing, whether they actually have the right to be foreclosing, and it can have a huge impact on whether they're able to engage in loss mitigation. So requires a lot of understanding of how these mortgages were securitized. Sometimes it requires doing research on databases of securities transactions where you can actually access the pooling and servicing agreements, which may or may not substantiate their claims that there's something that bars them from doing the kind of modification that you want. So corporate law is a big chunk of what we do. And related to that, which I didn't put on the slide, but so much of what governs the foreclosing lenders is governed by banking law. New York has several provisions that impact our work, subprime lending protections and high cost loan protections. So that is part and parcel, and there are mortgage servicing regulations that were promulgated by the New York State Department of Financial Services, which are a tool that we use. So banking law is front and center. Of course, negotiation skills, because a huge chunk of your lives is doing loss mitigation at the settlement conferences, and you don't think about it, but you are using your negotiation skills as part of that process. Tax issues are implicated in all kinds of ways. Obviously, there are property tax foreclosures that Kirsten mentioned. We're not covering that today, but nonetheless, that most of us do a fair amount of work around tax lien foreclosures, and there are income tax implications for clients who do achieve modifications sometimes, and usually we are not necessarily the ones giving the tax advice, but we need to be sensitized to those issues and have a basic understanding of what can happen if there is debt that is forgiven, and make the appropriate referrals to make sure that clients understand what the issues are. And then a whole host of consumer protection and civil rights legislation is implicated in what we do. The Truth in Lending Act, the Real Estate Settlement Procedures Act, the Fair Debt Collection Practices Act, Fair Housing Acts, which again, I didn't put on the slide, but Kirsten already covered this, but there is often some sort of lending discrimination lurking beneath the surface of our cases. And it's really important to be aware of that and be aware of the predatory conduct that really targeted certain populations. And New York's Deceptive Practices Act, UPL 349, again, is a huge tool for us, although it could be a lot better. Bankruptcy is an important tool that is often used. I think some of our offices use it more frequently than others, but it's definitely implicated. And there are some clients for whom bankruptcy is going to be a tool that you're going to want to consider. And then there are a whole host of other ancillary issues that often touch on our work. Trust and estates and elder law. We often have issues with properties that were owned by people who have passed away, and it's the heirs who are coming to us, and we have to sort out those issues. Government benefits, family law, all of these subjects intersect with this work. And then the other thing I just wanted to mention, also not on the slide, is Kirsten mentioned how vigorous and robust so many of the consumer protections that we have that are built in to the New York foreclosure process. And that is definitely true, but also just to pat ourselves on the back a little bit, most of these protections were the result of advocacy done by this community of people working with homeowners across the state. Going back more than a decade, more like 15 years, virtually every aspect of the pre-foreclosure notices, the settlement conference process, extending them to reverse mortgages, making the process permanent, recent legislation which will be touched on and be the subject of a later training on statutes of limitations. Virtually all of these things resulted from the fact that this community has developed expertise and gets asked by the legislatures and by government agencies such as the Department of Financial Services. So this community and the work that we do has really been important in informing New York's policy response. So I think that's all I have for this slide. So Kirsten, if we could advance this slide, the slide. Okay, so this is the part where I'm supposed to be doing what Kirsten said I was going to be doing, which is actually sort of just trying to describe what the foreclosure process looks like. And I am not a flowchart person. And I think our process in New York is really difficult and not necessarily susceptible to being explained on a flow chart like this. And I think if you stare at this for 30 seconds and then look at a plain white wall, your head might start to explode. So I wouldn't recommend like trying to look at this too closely for too long, because I think it's like one of those test patterns. But I'll try to nonetheless give a basic overview of what is supposed to happen. As I said, this is a process that happens in court in this state. So basically, the plaintiff has to win its case to be able to exercise its right to foreclose on its security interest in a property. So as it's laid out here, a homeowner misses payments. And the first thing that has to happen before a lender can bring a foreclosure case in court is they have to provide a 90-day pre-foreclosure notice. And there'll be a little bit more detail on that, I think, on the defense when we have a conversation later on in the day about defenses. But I think by now most of you are probably pretty acquainted with it, and there's a lot of constantly evolving law on the subject. But it's a requirement that is interpreted very strictly, and it lays out very specific language that needs to be in the notice, and very specific requirements about how it is served. And it does give us an incredibly powerful tool, because it is what is called a condition precedent. If they haven't complied with it strictly, their case fails. And even after it, the law has basically been on the books, although it's been amended a few times. The basic parameters of the law have been on the books since about 2008, and still a shocking number of banks' cases are lost because they still haven't gotten it right. And right now there's a case kicking around at the Court of Appeals that's probably going to rule fairly soon on what's called the Kessler issues, about whether there's a requirement that whether the law is not complied with if additional language is put on the 90-day notice. There'll be more about that later, I assume. So assuming they've done the 90-day notice and that provides them the required information and the opportunity to reach out to housing counselors, then foreclosure case is started in the same way that any other litigation is started. They file a summons and complaint. The one thing that is also different from any other kind of case that doesn't affect real property is They have to file what's called a lease pendens, which is officially called a notice of pendency, but conversationally we call it a lease pendens. That is a document that is filed with the county clerk's office that puts the world on notice that there is a lawsuit affecting title to property. So you can't foreclose if you haven't actually filed a notice of pendency. And then the case is served. Assuming that they serve the summons and complaint, an answer is required. That's a written answer. In a normal case, that's generally due between 20 and 30 days after service is effected. I'm not going to go into the nuances because there are all kinds of wrinkles about exactly when an answer is due. But normally you have that one opportunity to answer, which of course can be consensually extended. We lost the slides, disappeared, Kirsten. But I'll continue talking, but might be good if we can get that back up there. In any event, so an answer is due. Then we have a mandatory settlement conference process. Thank you. It's back. So a mandatory settlement conference is supposed to be scheduled within 60 days. As a practical matter, in the real world, most courts take longer than that. And this has been really transformative and has really given this community the opportunity to really shift the realities on the ground, because many homeowners, when they receive a summons and complaint, when they're served, they're completely at a loss about how to respond to it. They don't understand the language in a summons that says you must answer this complaint within 20 days or 30 days. They don't understand that answer actually means putting in a written document, and they may think that just appearing at their settlement conference, or they may think that just calling their servicer is answering, when that is not the case. But what we learned is that when they get a notice from the court that says your case is scheduled for a settlement conference on such and such a date and such a time, many of them actually appear in court. And that has been, for many of us, the vehicle by which we've been able to connect with homeowners and get them representation, at least limited scope representation, for the settlement conference phase of the case. So that's been pretty transformative. Another thing that's been transformative is that the law was amended in 2016 to provide a protection that other litigants don't get. At their first settlement conference, the court is required to provide all kinds of information to the defendant about the availability of services and what it means to answer a complaint. And in fact, they get another opportunity. They get 30 days from their first settlement conference to put in an answer to the complaint. And that has been really transformative because the homeowners who were there, we've been able to establish mechanisms varying from one court to another. But basically, if they make their way to the settlement conference, there's a much better chance that they're going to get referred to a legal services provider. And legal services providers, even if they can't take on their representation, they can always, and we always do, provide assistance with putting in an answer within that deadline so that defenses are preserved and it can't just be a default process. So if you look at the right of this chart, what would normally have happened before this whole process happened, the homeowner would default, and that was about 90% of all cases before 2009 resulted in default judgments. So if they didn't answer, the plaintiff would move for a default judgment and an order of reference. The order of reference is the process by which the case gets referred, usually to a court attorney referee, who will conduct some sort of process, some sort of evidentiary process for purposes of ascertaining that there was a default and what amount is owed, and then make a motion, make a recommendation, a report and recommendation that there be a judgment of foreclosure and sale issued in that amount. And then there would be a motion to confirm that referee's determination, which would result in a foreclosure judgment. And then the process for putting that case on the auction calendar would happen and the property would be sold. But presuming that the homeowner doesn't default and shows up in the at the first settlement conference, that won't happen immediately. Instead, they will get an opportunity to have the settlement conference process. And many of you already know by now that the process can go on for quite a period of time because dealing with servicers can take quite a while. But some of the cases will get resolved through the settlement conference process, and Kathy's going to be talking about that later, so I'm not going to go into detail about the legal standards that govern all of that. And then, if the case is not resolved at the settlement conference process, then the case will proceed the way any kind of litigation would proceed or should proceed in court. There can be discovery, there'll be a motion for summary judgment. If they can't prevail on summary judgment, there can be a trial, or as happens in some cases, the case will be dismissed because they didn't prevail on the motion practice or the defendant succeeded in getting the case dismissed. So I'm realizing I'm spending too long on this slide. I thought I was going to breeze right through it. Kirsten, if we could go to the next slide, and I think I probably have already covered this in covering the previous slide. So this goes over the specific authority for the 90-day notices, the RPAPL 1304 notices, and there's another form of notice that actually must accompany the complaint, the summons and complaint itself. That's called the Help for Homeowners in Foreclosure notice. That's the RPAPL 1303 notice. Both of these really require strict compliance, and I'm not going into all of the details, but if not using the right color paper, not using the right type font, all kinds of technical violations can actually derail the plaintiff's case. So there'll be more on that when we have a conversation about defenses. We can go to the next slide. I think so this sort of just reviews what is required to be on the 90-day notice. So I don't think we really need to spend a lot of time on this, but as I said, very, very specific requirements about every aspect of it. And also I would just flag, and Jennifer will probably talk about this later, but as a result of advocacy that we did a couple of years ago, there is now a separate version of the notice that is specific to reverse mortgages, which is pretty important, because with reverse mortgages, it was often the case that a case would be started and you didn't even know what triggered the default with respect to the reverse mortgage. And now there's a requirement that they provide pretty detailed information about why they're claiming the reverse mortgage is in foreclosure. So we can go to the next one, which I think we can also breeze through pretty quickly. Again, this is more detail on the 1303 notice, the Help for Homeowners in Foreclosure notice. Again, I don't think I need to really spend a lot of time on this. I'd rather, since we're really bumping up against the hour, go to the following slide, which is just flag that a phenomenon in recent years has been, because of all these protections that we have successfully gotten implanted in the New York State court process, we have some lenders who have attempted to avoid all those consumer protections and invoke federal diversity jurisdiction by bringing these cases in federal court. Not every case is going to have the perfect diversity that they need to have to bring a foreclosure case, but certainly in New York, we're seeing quite a few of them. And I know I've heard from advocates across the state that it happens elsewhere as well. And it's problematic because even though in general, the quality of adjudication in federal court is much better, because the settlement conference process and the various other things that we have built into the process are not within the federal rules. And because we're not there in those courts and there aren't dedicated settlement conference parts, it's very easy for plaintiffs to go into federal court and get a default judgment. So I just wanted to flag that. We have a whole separate training that we've done, and we may repeat it in the coming months, about dealing with foreclosure actions brought in federal court. And federal court's not a bad place if people are lucky enough to get to us, because we can actually get better results sometimes in federal court. But the problem is the people who don't reach us. There's that. So I apologize for spending way more. I told Kirsten I didn't think I needed more than 15 minutes. I guess I don't know myself very well. But if there are questions for my part of the conversation, happy to address. Sorry, I haven't been looking at the chat while we're going, but.
Lisa, are there any questions?
No, there's no questions in the chat. Just a quick housekeeping item. If you can't locate the written materials, they may have gone to your junk email. If you still can't locate them, just let me know. You can direct message me in the chat or email me. I put my email in the chat, and I'll work on that.
Jay, since we have 2 minutes and if there aren't other questions, I'm just going to ask you because I didn't cover it. Just say a note on condos maybe and co-ops and applicability of protections. I think folks in New York City probably will see those more.
Right. So condos, basically the process is the same because condos are still considered real estate. So they're a foreclosure under Article 13 of the Real Property Actions and Proceedings Law. So they're pretty much, although there are foreclosures on condos that are bought by banks because the borrower defaulted on their loan, but there can also be foreclosures brought by condo boards if there is a default on maintenance charges and things like that. That is something to be aware of. And then of course, co-ops, which is mostly a New York City thing, although in some of the suburban counties of New York, you also see co-ops. Co-ops are not actually considered real property. They are personal property. You own shares in a corporation that has attached to it, a proprietary lease. So those are not governed by the judicial foreclosure process at all. They are non-judicial foreclosures, and they happen the same way that the foreclosure on any kind of UCC, any kind of Uniform Commercial Code lien happens. So it's a non-judicial foreclosure with very little process brought in, and it's more like practicing in a place like California if you're dealing with co-ops because it's non-judicial. So if a client comes in and their shares have already been foreclosed on, you have to go in and bring an affirmative case in court to set aside the sale. It does, we do them in New York City. It's much more difficult process. And so yeah, that is something to be aware of. That is just very different, and it's a whole different process. And you can feel the pain of our colleagues who do this work in non-judicial foreclosure states when the co-op cases come in. So
thanks. Anybody else? Any final questions from anyone? All right, well, we are right at 10:30, I think. So we have a 15-minute break. Is that right, Lisa? Okay.
Yep, we are taking a 15-minute break and we'll resume at 10:45.
Great. Thanks, everyone.
thanks, everybody.